Welcome to this Euranet Plus debate on poor man's justice, the right to legal defence in Europe, presented within the Citizens' Corner concept. The debate is produced and hosted by Euranet Plus and RTV SLO Slovenia, a member of the Euranet Plus network. The debate can be followed live in the European Parliament on the Euranet Plus Inside website and on our Facebook profile, as well as on Twitter using the hashtag Citizens' Corner. I'm Brian Maguire. Joining us today to discuss the right to legal defence in Europe, Ivo Vajgl, a Liberal MEP from Slovenia, Francisco Fonseca Murillo, Director for Criminal Justice and DG Just, he'll be joining us later, for Alex Tinsley, Legal and Policy Officer and Head of EU Office at Fair Trials. And we're also joined by students from our university campus networks, Małgorzata Aleksandrowicz from Warsaw and Isra Ayash from Zagreb. Welcome to all of you. Alex, let's kick off with a really simple question. Where in Europe would you most like to be arrested?
Thank you. And simple answer, nowhere. Cooperation between the criminal justice organisations of member states is based on the idea that there's a standard right to a fair trial which is protected to the same level everywhere in the EU. But unfortunately, that's not the case in practice. Fair Trials receives inquiries every day from citizens arrested throughout the Union, and we work with lawyers across the European Union, all of whom report very similar issues. Lack of access to interpreters, lack of access to lawyers to provide advice in police stations, inappropriate information given about procedural rights so that people don't understand the situation and end up on the wrong end of unfair convictions. These aren't just abstract things, they're resulting in findings of violations against, including very old and established member states. So the simple answer is that justice in Europe is not quite up to scratch yet, and you don't want to be arrested anywhere.
Okay, Ivo Vajgl, why do we not yet have a coherent approach to legal justice, particularly for those who are arrested across the European Union?
I think we should not lose from the eyes the fact that European Union is extremely heterogeneous according to the history of singular states and traditions and schools of law, and there are the countries of transition who have their very specific problems and phenomena because of which some people are prosecuted, and then we have very different sensibilities of the public opinion, of media, and of different behavior of the politicians. You have the countries where justice and rule of law is undisputable. Politicians that do not take the right to criticize the decisions of the court and to the system of justice. You have traditional countries with traditional democracy where the law is there for 100 years or even more, and then you have the countries who are just building up a new set of values on which the law and the rule of law is based. Okay. So these are just the some of the reasons why we cannot speak about equal values or equal justice in all countries. And then we have the countries where with a free flow of people. So somebody who probably would not complain in his own country if he would be prosecuted for something is very loud and sensitive if he is prosecuted in another country in which he just came. So it is just Europe is still a process, and the rule of law is something very important in this process, which has to be
Let me ask
looked
Alex.
at.
Alex, coming from some of the older member states as well, we presume that there's a right to a fair trial, that you have a right to be presumed innocent when you're arrested. Is that the case?
It's legally the case that, of course, you have a right to be presumed innocent, and in this regard there are clear established standards that emerge from the case law of the European Court of Human Rights. But unfortunately, it's not the case that they're respected in the same way in all member states. The same norm features in all the constitutions, and it's notionally there. But what it means in practice varies a lot. For example, in some countries, suspects are presented a certain way in court, wearing handcuffs. In others, they're not. That may impact on the way that person is perceived when they're being judged. There are examples of authorities making public statements about a person's guilt before they have been tried, or even after they've been acquitted, which obviously is contrary to that presumption. So there are a lot of problems in practice, and this is why the European Union has taken the initiative to continue its work on criminal justice by proposing a directive to address the presumption of innocence, building on the existing measures.
Is there much pushback from member states on this, or is this something which they know they have to do?
The whole project of the European Union legislation on defence procedural rights in criminal justice arises from cooperation between member states, which is on shaky foundations at present. The member states knew that they had to act because there were judgments coming out of the European Court of Human Rights showing that established member states like Scotland in the United Kingdom, France, had to adopt quite significant reforms to bring themselves into line. And so there was a clear consensus that action was needed, and it began with measures on access to a lawyer, the right to interpretation and translation, and the right to information. And it is continuing now with further directives on the presumption of innocence, legal aid, and safeguards for children. But these are controversial measures for the member states because they address core parts of criminal procedure.
Okay.
But it's not optional. These are core parts of the right to a fair trial, and if cooperation is to work effectively, it's not an option. They have to be completed.
Okay. Ezra, you have a question for our panelists?
Actually, I want to know how can the implementation of the directives that are suggested be ensured both in legislation and in practice in member states?
Let me give it to Ivo first. Ivo, do you know how quickly they can implement the directive? Do you think there should be tolerance for a longer transition period, or should it be done immediately?
It will take quite a lot of time. I think it is important that Commission is working on it. It's important. Every piece of European legislation is important because it sets standards, and probably for many countries it means the introduction of completely new procedures, even new values. But the implementation will take time.
Okay. Alex, what do you think? How long will the translation into member states' legislation, how long will it take?
Fair Trials works actively on this. The office I head in Brussels coordinates implementation activities with lawyers across the European Union. And what we're seeing is that the first measures have been adopted by the EU, but they're slowly being implemented within the member states. Some laws have been adopted by and large, but in some places transposition is late, and elsewhere the practice on the ground remains very much behind schedule and still in need of updating. So we have ongoing conversations with lots of member states, cases in the national courts, where we're trying to ensure that this implementation process happens. And it's absolutely a priority that it does happen, because that's only the very first step. It's only once that happens that the EU can then continue on with the job of strengthening mutual trust.
Ivo, for example, we have the European arrest warrant now as well. How can you justify to your constituents that the justice they have and can expect in Slovenia, they may not receive in another member state, and yet the arrest warrant may apply to them?
Well, it is difficult to explain it, but of course, as I told you, I think that growing together of European Union on the field of justice goes slow. It has of course something to do with the practices and tradition in each and every country. but also with the efficiency of implementation, which is of course the matter of politics, not only of justice. So it is the parliaments who have to adapt it and work on the national legislation which would implement the spirit and the words of the directives.
Okay, Margosata, you have a question?
Yes, of course. So does European Commission or does European Commission or European Parliament is able to ensure what we translated will be at good level?
Okay, Alex, in practice, the right to an interpreter, and how do we standardize quality of justice? Not just the right to it, but the quality that you would receive as well.
The quality of interpretation is one of the big implementation issues. The Legal Experts Advisory Panel published a strategy focused on certain key areas of implementation, and that was the top one. We regularly hear about just members of the expat community providing informal interpretation for police, unqualified interpreters, particularly within police station setups. So there is a great deal to do in this regard. There have been laws adopted that frequently just say interpretation must be of a satisfactory standard, and it's not clear how that's to be enforced. And unfortunately, where by and large in the European Union there isn't video recording of what goes on in police stations, it's very difficult for courts later on to figure out what happened and to assess whether there has been unfairness. So on the one hand, it's important for member states in implementing this directive to set clear quality guidelines, including on the control of the profession of interpreters, but also in the way recording and records are kept of those interviews. And it's also up to lawyers to make sure they raise the point.
Ivo?
I would add to what you have been saying. Yes, I think it is extremely important to have engaged and vigilant civil society concerning all these new standards in singular countries. This is something where indeed civil society can make its contribution by exerting pressure on the government, even on the courts, in order to apply what is understood as a basic right of the persons who are the subject of the legal process. Here I mean the right on defense. Here I mean the right on use of language and all other elements of a fair trial.
Okay, Alex.
I was just going to add that that's indeed crucial, that bar associations and interpreters associations play their part, but obviously the European Commission has a key role here in ensuring application of the directives, both through the strategic use of funds, but also through infringement actions where necessary, where member states haven't taken action in practice. And equally, the national courts have got a big job to do in ensuring that these standards are taken up in practice.
Okay, Ivo, let's get the idea of the cost of justice as well, poor man's justice. Has legal defense become so expensive that really there is no right to a fair trial? There is no real right to a legal defense?
Well, probably it is true that somebody who does not have the means to engage somebody to defend a lawyer is definitely in the precarious position. Not only in the new member states of European Union, but also in the old. Sometimes it is obvious that with a lot of money you can make a difference in your treatment. There are some cases which I will not going to speak about in United States but also in Europe, where it was obvious that somebody with a lot of money and political image and influence can can influence the decision of the court, and the poor guy is mistreated.
Okay. Alex, which countries which member states are good with legal aid, good with legal defense?
Again, I go back to my first answer to your first question, that there are problems in all member states, and all member states have blind spots where they don't realise what they're doing wrong. Of course, there are some member states where we hear that there isn't simply an effective working legal aid mechanism at the very early stages. But the key point on this is that, again, this isn't something that's optional. Yes, it costs money, and yes, there are budgetary implications, but there are also budgetary implications of getting trials wrong, trying people unfairly, which results in huge human cost, but also in expensive retrials.
We see this in the UK a lot. We
wasted
see a
time.
lot of expensive trials in the UK, and at the same time, the legal aid budget has been diminished to the point where lawyers are saying we can't afford to do this anymore.
They are saying that, and that there are different approaches to legal aid systems within the EU. But what's again key from the perspective of this institution here, the European Parliament, is that the EU acts to make sure that there's a common minimum standard. It has proposed a directive on legal aid, which was, the Commission proposed a directive on legal aid, which was pretty narrow in scope to cover just people who'd been arrested, and only at the very initial stages of proceedings. The European Parliament has sought to strengthen it by making sure it applies to the whole process and to all people. But nevertheless, the Council is seeking to keep it very limited, which is causing a lot of division. So that really has to see a successful result. Okay,
just before Ivo Weigel goes and Francisco Murillo just joined us, welcome. Then I want to ask you, has austerity affected the quality of justice? Have budget cuts impacted on the right to a fair trial?
It should not, but it does.
Good answer. Off you go. Thank you very much. Francisco, good to see you, sir. My question to you, I started this same question with Alex. Where in Europe would you most like to be arrested?
Sorry?
Where in Europe would you most like to be arrested?
Well, it depends on the crime, it depends on the country.
Choose your crime.
So, no, I mean, it depends. Each country has its own laws, and we are not creating a 29 legal regime. We're just trying to approximate legislation and to ensure that respecting the rule of law, and that is, frankly speaking, we have maybe the highest standards in the world in respect of the rule of law. We need to ensure that citizens, business, could enjoy all the freedom of movements. We need to approximate legislation, and where there are the holes, the gap, we need to come with specific procedural guarantees, not to change radically the national one, but to adapt to this cross-border reality.
Okay, Ezra, you have a question?
Well, if you just adapt some laws, wouldn't it be different in different member states? Because, for example, I'm from Croatia. Croatia doesn't have neither similar laws to England, and if you just adapt one and the other, one will be much more developed and adapted than the other.
Yeah, but that is probably the originality and the difficulties of this European process of integration. You like Croatian, me like Spaniard. We have national rules concerning our fundamental rights, concerning the right to a fair trial. We have a common standard, the Standard European Convention on Human Rights. And for example, in Croatia or in Spain or whatever, there is a problem with the standard established at European level by the European Court of Human Rights. We can go to European Court of Human Rights to require for that. That is very, the statistics are incredible. In the last 10 years, we have at least 25, 26 case law of the Court of Strasbourg condemning states for infraction of the rule of law. But if I can, that is, you need to respect your national law needs to respect the standards of the European Convention on Human Rights. Secondly, you are Croatian, but you are living in Spain. You are suspect in Spain. What are my rights? Are they Croatian? Are they Spaniards? No. We need to have European standards, proper European law on this issue, and we are working on that. We have 3 very important directives on place, and we have 3 others in discussion with the Council of the Parliament. To complete the figure, not your problem like a Croatian in Croatia, Either it's good or you go to Strasbourg. But your problem in Croatia, you are suspect or in prison or whatever problem in Spain. For that, we need to fill the gaps.
Okay, Alex, to which degree do politics dominate rather than legal process when it comes to the implementation of laws? Are we in a moment where, for example, migration, people are prepared to compromise the basic provision of a good defense because these are different times and we're a little afraid in the country that the politicians shout too loudly and the law takes second place? Does this happen?
The standards that have just been referred to that come out of the European Court of Human Rights are very clear on this, that it's in critical times and in serious cases that standards need to be respected at their fullest, and so there isn't some principle that things can be watered down when times are tough.
Let me ask Francisco, what are the infringements then if a country doesn't adhere to the Courts of Justice, the ECHR? What happens? How do you compel them?
If one state doesn't respect a decision of the Court of Strasbourg, there is a special procedure. The Council of Ministers or the Council, that is not my business, that is the Council of Europe, of course, but you need to have, there is a monitoring process established by the ministers, representative of the 48 state part in the Council of Europe, and they take decisions on majority. Decision majority, they can be compulsory for the state. But of course, that is the justice of the Strasbourg jurisdiction is not a remedial justice. It's just to restore the failure.
Okay.
Because we are talking of fundamental rights.
Okay, so Alex, in the context of Hungary, for example, where Viktor Orban decides, well, these migrants shouldn't be here anyway, and he interprets the rules according to his own pleasure, and he knows that the European courts are going to take minimum 3-5 years to do anything about it. And what's his incentive to actually obey?
First of all, I'm not best placed to comment on the migration situation, but since you take Hungary as an example, we hosted an expert meeting in Hungary with judges, lawyers and other criminal justice professionals a few years ago, where we identified some quite clear questions that posed fair trials issues at the time relating to the length of pre-trial detention in that country, and reforms were undertaken to extend the limit for pre-trial detention in a way which is extremely concerning in light of well-established standards on pre-trial detention. And here we see again the problem with the implementation of these existing standards and the need for EU action, because beyond everything it's done already, this is the core fundamental problem that undermines cooperation between member states is pre-trial detention. Thousands of people detained whilst they're still presumed innocent when it isn't necessary or appropriate to do so. That's just one example. There are examples from many different member states. And this is a key area where the EU needs to continue its work.
Francisco, why is this such a continuing issue, the pre-trial detention?
More and more, I agree with you, the question of pretrial detention will be in the focus of European action. Because in this European free space, it's clear that if you have a problem in a country that is not your country, you have more possibilities than a national one to be more in pretrial detention. So, of course, the question is very difficult. We need to find the good legal basis. That is not evident. We need to have the political will, and that is another issue. We need to propose something convincing, not too much invasive, but convincing. And one very particular point is to take this problem on the different parts where we can act directly. For example, on the 19th October, excuse me, there's not big propaganda, but it's very useful. 19th October, we have a very important ministerial meeting in Brussels, hosted by Commissioner Jourova, just to discuss the problem of the radicalization in prisons, that is very important at this moment, because the prisons are overcrowded. How to deal with that? Other example concerning pretrial detention. We have a specific corpus in European law concerning victims and vulnerable persons. And happily only after the 16th November, but I mean in 1 month. That means that all judges, all police authorities are obliged concerning children, vulnerable persons, victims, to have specific requirements concerning the professionality, the information, the sensitivity, and the tailored measures undertaken with all these people when they are in pretrial conditions, pretrial detention, sorry. So we have not a global mandate to harmonize this question on all the different dimensions, but we need to act point by point.
Okay, we have a question from Irene Benedicto from Facebook. And she asks principally, okay, we've talked about citizens in Europe, European citizens, but what about refugees and migrants when they arrive? Do they actually have access to a fair justice system once they arrive in EU territory, or do we deal with them differently? Alex first.
Again, I'm not going to speak about the migration situation, but it's true, of course, that a person in the position of a newly arrived asylum seeker faces pretty difficult challenges if they end up caught up in a criminal justice system. They likely won't speak the language, they won't have resources to support them, and so they absolutely need member states to ensure the application of these standards we've been talking about. Legal aid funding to ensure they can get legal defence, proper interpretation to ensure they're fairly understood. These are absolutely core fundamentals, and it's things that it's important for the EU to respect at home when it's promoting human rights abroad.
Okay, Malgorzata, you have another question?
Yes, of course. So my question is, do European Commission will also consider issue of, for example, civil law or only criminal?
Francisco.
We are concerning victims. Concerning victims, we have, of course, the criminal protection, but also the civil one, especially the question of compensations for victims, and the question is very important in the European context, on the capacity to, if you have a protection order, to travel abroad and to be protected by your civil or administrative measure abroad your national border. Of course, we are trying to cover all the dimensions.
Okay, I'm surprised by some of the links that are made in the Facebook comments here, actually. And there's one really simple, but I think very good question. Who controls EU justice, Francisco?
Who controls?
Yeah, who controls EU justice?
The European Court of Luxembourg.
Okay.
Like in any rule of law situation, we have a jurisdiction, and the jurisdiction controls the European Union justice and European Union law. It's not the first time that the Court of Justice, it would be not a premiere if the Court of Justice cancel or annul or repeal a legislation adopted by the Council and the Parliament.
Okay, do they have a right of initiative or must they be petitioned?
Before the European Court of Justice, before the European Court of Justice of Luxembourg, the institutions, I mean the Commission, the Parliament, can request the Council, but any national jurisdiction, if you have a doubt on the interpretation or on the legality of a European Union measure, you are obliged, like national jurisdiction, to request the answer to the Court of Luxembourg. That is the preliminary, we call that preliminary ruling.
Okay. Alex, you have a comment there?
I would simply add that this brings into focus the role of national courts and national justice systems in this process. These directives were all adopted to ensure that national justice systems were doing a better job, and it's the national justice systems which have the responsibility now to implement these standards and to seek guidance from the Court of Justice where necessary. These are new issues for criminal courts, and there's only been 2 references so far, so there's a long way to go.
I have the sense that if you have European health insurance, is it time we had European legal insurance, Francisco?
European health insurance?
No, for example, that if you live here in Belgium, you have to pay, it's mandatory that you pay a contribution for your social security, and you have an entitlement to...
Exactly. And you can transfer this health insurance to another country. But of course you contribute. I suppose the question is linked to a recent decision of the Court of Justice, the Abalamanis, that established that if you move to another country, but you are not looking for a job, that is not automatic that you receive health insurance in these countries.
Okay, well, my question is, could we translate a similar kind of system into legal process? You would have, you'd be paying into a legal defense fund across Europe, therefore you'd be...
you're concerning that. Not for tomorrow. I mean, we are, the discussion on the legal aid directive is advancing well, slowly but well, and especially the European Parliament has a fantastic rapporteur, Mr. De Jong, but the question is very tricky. For the time being, the idea is to have you use your national system of legal aid for free, also for non-nationals. But to have a kind of common, a clearance, mutual clearance system is not for tomorrow.
Is there, here, if you're a functionary within the Parliament, for example, and I'm sure it's the same with the Commission, your health insurance for a family, for example, is supplemented. So wherever the gap is, the institutions will pay for it. Do we have some sort of global sum on the horizon where if your national state fails, Europe will take care of it, so there's a harmonization?
Well, that is not criminal justice, of course. But it seems to me difficult that European state fail, frankly speaking. And if you talk about the complementary pension, that is a private right. We have the right, of course, just in order to have in the future a complementary pension insurance system.
But in the sense that the European Union would pay for the legal aid where a state fell below the threshold, or is that something feasible?
European Union budget, I don't think so,
okay,
frankly speaking. But I insist, it's a question that we could discuss if there is a political will, but we have not a clear mandate on that.
Okay, very well. Another question from our students today?
Will the directives have impact beyond the borders of EU, for example, in the states that want to join EU, and how will it manifest?
Francisco, you mentioned about the 48 member states, 48 states, not member states. So what's the impact that European Union law has beyond our borders?
In our borders.
Beyond our borders.
Beyond our borders. But the external dimension of our policies. In the terms of in justice issues, for example, also in criminal and in civil, we are negotiating and signing or ratifying international treaties with the most important parts of member states, from the data protection file to the mutual legal assistance, extradition agreements, etc., etc. It's the external dimension of our own internal policies.
Alex?
I think it's important to add to this that what is going on internally with these directives, the world looks to Europe in some ways for leadership in this regard, and the EU has a chance to set a gold standard here, and we see already some effects. These directives have been taken into account by the European Court of Human Rights in cases which have a radiating effect throughout the region. So it is important from the perspective of the global perspective that the job is done properly.
Okay, we've just a couple of minutes left. Francisco, what would you like to see happen next in European justice? What would please you most in terms of a sense of fair justice across Europe?
To have a full comprehensive system on legal aid and presumption of innocence. To have, first, secondly, to have a full implementation of our rules on victims' rights, because victims are vulnerable persons. And third, to have a more friendly justice. We are developing very important tools in the so-called e-justice, but we need to really to explain to business, to citizens, that to have a to receive a fair justice at European global dimension is also possible.
Alex, same question. What would you like to see as in the next couple of years as the cornerstone of European justice?
3 things need to happen. The member states need to implement the existing laws with the oversight of the EU. The EU needs to finish the job of adopting the standards on legal aid, presumption of innocence and safeguards for children, and the EU needs to act on pretrial detention and start thinking about measures on audio-visual recording and remedies. If those things can happen, there'll be a stronger basis for cooperation between member states.
Okay, we're going to sum up in just a moment. Other issues that we've got on Facebook today. What is fair justice when we have ISDS and TTIP? You thought you couldn't link that with criminal justice, but there we have it. There's a sense that how can we trust our justice system whenever we're creating courts and moving about the dimensions of what could be considered to be fair judgments. Also, we have financial help to travel to another state in the event of a trial. What if you can't afford it? Will you be convicted in your absence? And also troubles in the workplace as well. That's civil law. We'll deal with that another time. Thank you to our guests. We'll come back in just a moment, but let's summarize what we discussed today. The standard right to fair trials, it doesn't really exist across Europe yet. There is a lack of access in different ways, and part of this is caused by diversity of legal systems. Public opinion plays its part, political opinion, and the role of the media shaping the impact and the implementation of the law as well. The maturity of legal systems and how in practice law is applied. The impact of the European Court of Human Rights, and it's effectively works as our Supreme Court at the moment, and the leadership and direction that's given to the member states. Speed of justice is critical as well, and infringement proceedings and in terms of how we get a remedial situation as well in the event of a breach. Quality of interpretation, a critical element which needs a lot of attention. Standardized quality as well. How do we make sure that everybody gets the same quality across Europe with so many different situations? The role of civil society, Eva was saying, is really important to continue the pressure against politicians and the adaptation of national realities as well. Migration is testing our legal systems to the limit and the tolerance of people on different sides of the political spectrum in different ways. Pretrial detention is also a critical element which really needs to be addressed in the near future. And Francisco summarized his wish list with a full and comprehensive system across Europe, and also Alex is talking about victims' rights as well, how we deal with victims' rights in a more turbulent society today. Overcrowding in prisons, the list is endless. There's so much to do. Francisco, my very best wishes to you on that front. Alex Tinsley, thank you very much for joining us today, and to our students, Malgorzata, Aleksandrovic, and Aza Ayash. Also to Ivo Weigel, who has left us now also. Thank you very much for your participation today. Let's hope that there is no more poor man's justice.